Hey everyone, this is Sahil Malhotra, Principal Attorney at Vrishi Law, an intellectual property law firm where I help small businesses, startups, and creatives build and develop their intellectual property portfolio. A brand owner develops a trademark portfolio to protect their goodwill amongst customers and the marketplace. In the journey across trademark ownership, you will often come across terms such as trademark abandonment and trademark ownership transfer. Now, what these terms mean, this is what I'm going to explain in this blog today. Now, let's talk about what is an abandoned trademark. Now, a trademark can be abandoned in two different ways. One in the application stage and one even after registration. So your trademark isn't safe after you have registered it. In the application phase, a trademark application can be abandoned if the applicant fails to respond to the examining attorney. An abandoned application can usually be revived under exceptional circumstances, but I would try my best to avoid that situation. Additionally, a trademark application may be considered abandoned if the required filings are not filed in a timely manner. Federal registrations can be abandoned as well, most commonly through non-use. A federally registered trademark at the United States Patent and Trademark Office has the potential to be owned for infinity, although a responsible trademark owner has to ensure that timely maintenance forms are filed. Most of all, for a trademark to maintain its enforcement, the mark must be used in connection with the goods and services it is registered in. Your trademark is only as strong as much as you enforce it after registration. Abandonment is when a trademark owner no longer uses the mark and has no intent to continue using the mark in the future either. A trademark must be used more than once and show a bona fide intent to continue its market presence. An example is if a brewery is registered to sell, let's say, t-shirts and beer, well, it better be selling t-shirts 3 years from now as well, and better have continued use of that mark and sell in connection of selling t-shirts. A trademark owner may abandon their registered mark through evidence of discontinued use for, you guessed it, at least 3 years, lack of enforcement against third-party use of the mark, and licensing without quality control. You can't just provide blanket licensing to companies to use your name, logo, and goodwill if the quality of your original product is not being transferred to those people who are licensing your trademarks. Failing to file maintenance documents, as mentioned earlier, is another way you can abandon your trademark. Examples of maintenance documents are Section 8 Declaration of Use, Section 15 Claim of Incontestability, and a Section 9 Renewal. Above are just a few ways a trademark registration could be abandoned. Now let's talk about trademark ownership transfer. Trademark rights are developed through the actual use of the mark in connection with the products and services the owners provide under the mark. Registering a trademark at the USPTO allows the owner to enter into licensing and other commercial agreements seamlessly. A trademark owner may retain ownership of the mark even when providing exclusive licensing rights to third parties. This is where we talked about we don't want to provide naked licensing. We want to ensure that our quality, the goodwill associated with our products or services are transferred as well through the licensing process. But a trademark ownership transfer occurs through an assignment agreement. Assignment is completely different than licensing. Assignment is you're assigning your rights to someone else. An assignment must be in writing and is the legal transfer of ownership from the assigner, the owner, to the assignee, the purchasing party. The document must contain specific provisions for a proper assignment to ensure that the transfer is without future issues. For example, an assignment in gross can invalidate a trademark assignment. An assignment in gross occurs when the goodwill associated with the business is not included in the document. Such an act will deem the assignment invalid. To avoid future trademark infringement actions and other issues, the assignment document must state explicitly that the assignee will receive alongside the trademark the business's goodwill as part of the agreement. It is essential to consult a trademark attorney to avoid abandonment and loss of trademark rights due to improper licensing or transfer. Past studies and even the USPTO states that hiring a trademark attorney to represent you increases the chances of registration. If you need further assistance in acquiring a trademark registration, please book a free 15-minute consultation by clicking the link provided below. As always, this is Sahil Malhotra. Thank you for stopping by.